Good evening, friends. Today we shall discuss two small topics, that is interlocutory orders and appointment of receivers. Those are very small topics. Nevertheless, we shall discuss them because we have to finish the entire course anyway. So, without wasting time, let's just start with our discussion. It'll be a small lecture, I believe. Yes. So, the receiver, we'll discuss interlocutory orders, that is Order 39, Rule 6 to 10, and we'll also discuss the appointment of receiver, the power that is used by court, which is used not very often, but still it is an important power of the court. Interlocutory orders, these are nothing but the orders which are passed by the court in the interim. ଆମେ ଯେମିତି ଜାଣିଥିବା 457 CRPC ରେ we must have noticed, those who have gone through CRPC, that the things which are the subject matter, if any involved in a crime, if they are subject to speedy and natural decay, those were being ordered for an intermediate possession. So they were uh, left at possession of an intermediate person who was possessing the same, because or it was being sold because for the purpose that it will be of no value if it has been left like that. So similarly, in CPC also there is a provision of passing interlocutory orders, especially for the things which are subject to speedy and natural decay, and for the sale of same, orders can be passed by the court. So Rule 6 says that it talks about orders which are made pending the suit and before final hearing has been done on merits. Because it is essential for the suit, because it is essential for the subject matter of the suit, and it will not sustain the ଆମେ ତ ଜାଣିଛେ normally civil suit ର length କେତେ ଗୋଟେ research ରେ କହିଥିଲା, ମୁଁ ଏବେ I had gone through that normal ଗୋଟେ civil suit ଯଦି ଆପଣ କରିବେ ତାହେଲେ minimum ରେ ଆପଣଙ୍କୁ 9 years court ଯିବାକୁ ପଡିବ. So 9 years ପର୍ଯ୍ୟନ୍ତ for that matter, ଯଦି ଗୋଟେ suppose ଗୋଟେ property ରୁ ଗୋଟେ କିଛି ନଡିଆ ବାହାରିଛି, for that matter ନଡିଆ ବାହାରିଛି, ସେ ନଡିଆ ଉପରେ dispute ଅଛି, ନଡିଆ ଗଛର ନଡିଆ ଉପରେ dispute ଅଛି, ସେଇ ଯୋଉ ନଡିଆ ଗୁଡାକ those are subject to speedy and natural decay, ବର୍ଷରେ ତ ମାନେ 6 ମାସରେ ତ ଖରାପ ହବ ହିଁ ସେ ନଡିଆ. So in that case, the court on application can order for sale of such movable property by any person. On what grounds? On the grounds that it is subject to speedy and natural decay. ଖରାପ ହେଇଯିବ, ଆମେ ତାକୁ ସେମିତି କେହି ୟୁଜ ନ କରିବାଠୁ ବେଟର ହଉଛି those that shall be sold, ସେ ତାର ପ୍ରୋସିଡ୍ ଗୁଡାକୁ ପରେ ପଛେ ଲେଟର ଯଦି ଆଉ ଗୋଟେ ପାର୍ଟି wrongfully obtain କରିଦେଲା ତାକୁ ପଛେ ଦିଆଯାଇ ପାରିବ, but it should be sold first. The thing that is there right now, if it is subject to speedy and natural decay, they should be taken care of first. That is the intention of the legislature. Rule 7 also talks about detention, preservation, and inspection, etc., of subject matter of the suit. So, under this rule, the court has the power to order for detention, କିଛି property କୁ ରଖିପାରିବେ, preservation କୁହାହବ କି ଏ park ଟାକୁ ତମେ ଏଇ way ରେ preserve କରି ରଖ. inspection ମାନେ ଯାଇକି ଆପଣ sample collection କରନ୍ତୁ or କିଛି experiment କରନ୍ତୁ, ସେ କହୁଥିବ କି ଏଠି ଏଇ ଗୋଟେ allegation suppose ଆସିଲା ଯେ ସେଇଟା ଗୋଟେ ତେଲ ଖଣି ଅଛି, ଯେମିତି ପୁରୀରୁ ଆମେ ଏବେ ଶୁଣିଲେ news ରେ that ଗୋପର କିଛି ଗାଁ ତଳୁ there has been discovery of oil fields, so ଏବେ oil ତା ଭିତରୁ ବାହାରିବ. So ସେଇ property ଉପରେ କିଛି dispute ଥିଲା. Now the court, regarding the value of that property, there is a challenge, and the court thinks that it should be inspected. It should be inspected by proper authority to certify whether there is in fact oil under that ground, so that the subject matter of the suit can be decided, and accordingly the pecuniary jurisdiction of the court can be decided. So in that case, the court can order for an inspection of the property as well. So court detention ପାଇଁ order କରିପାରିବ, preservation ପାଇଁ order କରିପାରିବ, inspection ପାଇଁ order କରିପାରିବ. For the same purpose, he can authorize any person to enter into the property. So normally आपण आउ का property रे बसेले it will be trespass, but court जदि एमती किसी order करूची and for the same you have to enter into a property, that is also allowed if it is allowed by the court. For that matter, samples can also be taken or observations or experiments can be tried for obtaining full information. जो example जो आपण example देली जदि oil टा अछि ना नहीं टेस्ट करले ही जणा पड़िबो, और सेटा ते हाई यील्डिंग से कोथबो allegation अछि कि जे सेटा ब्लैक सॉइल ता देरे अछि एंड सेठी हमरो ब्लैक सॉइल रे आपण पढिथिबे कॉटन कल्टीवेशन बढ़िया हुए, कॉटन कल्टीवेशन बढ़िया हुए ब्लैक सॉइल रे. So if that has been alleged and now the court is doubtful whether actually black soil normally हमें महाराष्ट्र फॉरेस्ट एरिया रे पाऊ, तो ब्लैक सॉइल कोन एठी एते अछि की, for that matter is test is necessary. For that matter the court can order for an observation or experiment to be tried on the same. For what purpose? To obtain full information. Now coming to rule 8. Rule 8 talks about the preceding rules, that is 6 and 7. Because 6 and 7 पे जो application हबो that can be made by the plaintiff. That application under rule 6 and 7 that can be made by plaintiff after institution of the suit anytime, and can be made by the defendant after his appearance. So it is obvious, it is but obvious that plaintiff institute कला पर से आसी गला से कर परियो पिक्चर को, defendant के पिक्चर आसो appearance पर तेणु ता पर से कर परियो. Of course the notice has to be given to the opposite party. ता माने जदि plaintiff करियो ताले defendant को notice दबो, जदि defendant उनके application करूची सेल पई और प्रिजर्वेशन पई और रिटेंशन पई और इंस्पेक्शन पई ताले से plaintiff को notice दबो. But there is also a special power that without giving notice it can be ordered if the very purpose would be defeated. ता माने से जो मु कहउथली नडिया एग्जांपल टारे, से नडिया एग्जांपल न नै कि धरंतु कदली पाचिला कदली बाहरछ, तो पाचिला कदली that bananas are subject to quick decay, and if you wait for the notice, the notice they have other party को, the other party would appear and object, and then there would be an hearing, and then there would be an order, and then only the sale can be done by mode of an auction or something. It will not be fruitful, it will defeat the whole purpose. So in that case notice can be spared with as well. Now coming to rule 9. Rule 9 says if the subject matter, so the subject matter of the suit, जो suitor रे subject matter अछि, if that is a land yielding revenue or tenure, ता माने जदि सेटारे तादरु किछि रेवेन्यू मिलुची गवर्नमेंट, एई रूल टा कहउची जदि से गोटे लैंड टा अछि जोटा कि सब्जेक्ट मैटर अछि सेटारू रेवेन्यू मिलुची, और टेन्योर गोटे टेनेंसी दिया हैची कि टेन्योर पई गोटे लीज दिया हैची और सेथुर भी गवर्नमेंट को किछि फायदा मिलुची. सो इफ that is there and सेटा एबे सेल करा हला, if that is being sold, then in that case the party is neglecting to pay, the party जे एबे पोजीशन रे थिला आगुरु बिफोर द सेल से पैसा देइनी, ताले बे जाहाकु नुवा नुवा जे पार्टी एबे किनिला आफ्टर द सेल, if he is paying the due rents then he will be entitled to get it. So basically it is the example is कि मु एबे गोटे क्वार्टर रे रहउची, फॉर एग्जांपल क्वार्टर रहउची, से क्वार्टर पूर्वर लोक माने जवान थिले से माने पे करनांती रे, if I am paying the rent on their behalf as well, I am entitled to the rent. So on the similar light, it is if it is a land yielding revenue and which the rent was payable to the government, now they have neglected to pay it, now the court has sold it, now the purchaser who, if he pays the said rents, then he is entitled to the payments of the rents that he has paid on their behalf. That is what rule 9 says. Now coming to rule 10. Rule 10 रे कहउची if the subject matter is money or thing capable of delivery, सेठी कहउची एठी सेठी तो फर्स्ट रूल 9 रे गोटे जिंस कहला जदी सब्जेक्ट मैटर इज land yielding revenue or tenure, rule 10 रे कहला if the subject matter is money or thing capable of delivery, ताहेले जदी सेटा गोटे ट्रस्टी होल्ड करूथबो, then in that case it will be directed to be deposited in court. तम जदी पैसाटा गोटे ट्रस्टी माने गोटे कहा बिहाफ रे धरची बोली से एडमिट कला से पार्टीटा, then in that case the subject matter टाकू will be deposited in the court or given to the original owner. जहा बिहाफ रे धरची ताकू डायरेक्ट कराबो कि तू धर, से ट्रस्टी पाखरे रखा न है कि कोर्ट रे डिपोजिट करिया पे कि ओरिजिनल ओनर को दबा पे भी ऑर्डर करा जाई पारी. Now coming to this actually finishes our interlocutory orders. Very small topic as I told you. Now coming to the appointment of receiver, that is order 40. That is again a very small topic. Nevertheless, we shall discuss them. Order 40 says talks about appointment of receivers. Now, who is a receiver? Receiver is a person appointed by court to receive and manage property and conserve, manage and dispose of the same in the manner necessary. ଆପଣ ଗୋଟେ ଏକ୍ସାମ୍ପଲ ଦେଲେ ଆପଣ ବୁଝିପାରିବେ ଆଗ ରିସିଭର ଟା କେତେବେଳେ ନେସେସରି ହୁଏ. The example would be, suppose there is a mall which is being managed by the uh, defendant. Now the plaintiff comes and alleges that the mall is in fact is his mall, and it has been willed in a will, it has been given to him by his grandfather, and the defendant who is managing it is wrongly in possession and ownership of the same. So in this case ଦି ଜଣ ଏବେ ମଲ୍ ର ମ୍ୟାନେଜମେଣ୍ଟ କୁ ଚାହୁଁଛନ୍ତି, କ୍ଲେମ କରୁଛନ୍ତି. ଏବେ କୋର୍ଟ ଦେଖିଲା ଯଦି ଆକୁ ଦବା ତାହେଲେ the other party will be at loss. ଯଦି ତାକୁ ଦବା ତାହେଲେ the other party would be at loss. So in this case court କଣ କରିବ to make sure that it is fair, ସେ ଗୋଟେ third party କୁ ଦେଇପାରିବ that you be appointed by as the receiver, and now you will manage the mall and conserve it and dispose it. ଯାହା ବି profit ଥିବ ତାର collect କରିବ. It will do everything on the behalf of the court. So it is nothing but it will act as a custodial leges. Custodial leges ମାନେ it will represent the court for the matter, because court ଯଦି ଏଠି ଧରିଥାନ୍ତା, court ର ତ ଦୁନିଆ କାମ ଅଛି, court ବେଶୀ କଣ ଏଠି manage କରିବ mall or ଏଇ ସବୁ ଜିନିଷ ଗୁଡ ଦେଖିବ କି? ତ in that case court କଣ କରେ, ନିଜେ ନ କରିକି ସେ ଆଉ ଗୋଟେ receiver କୁ appoint କରିବ who will manage that property pending the suit. or even ସୁଟ ର ପରେ ବି ସେଟା ବି କରାହେଇ ପାରିବ, ବେଳେ ବେଳେ ଡିକ୍ରି ପରେ ବି କରାହଉଛି ବୋଲି ବି ଅଛି, ଏଇ ଆପଏଣ୍ଟମେଣ୍ଟ ରିସିଭର କହିଛି ଡିକ୍ରି ପରେ ବି ଆପଏଣ୍ଟ କରାହେଇ ପାରିବ ଯଦି ତାର ଅପିଲ ସପୋଜ ଅଛି, ଡିକ୍ରି ପରେ ବି ଆପଣ କରିପାରିବେ ଟିଲ୍ ପୁରା ଯେପର୍ଯ୍ୟନ୍ତ ପୁରା ସବୁ ଫାଇନାଲିଟି ନ ହେଇଛି ସେ ପର୍ଯ୍ୟନ୍ତ କରିପାରିବେ ବୋଲି କହୁଛି. ତ ଇଟ୍ ଇଜ ଇନଫ୍ୟାକ୍ଟ ୱାନ୍ ଅଫ ଦି ହାର୍ଶେଷ୍ଟ ରେମେଡି, କାହିଁକିନା ନର୍ମାଲ କେସରେ ଆପଣ ରିସିଭର ଆପଏଣ୍ଟମେଣ୍ଟ ହୁଏ. ରିସିଭର ଆପଏଣ୍ଟମେଣ୍ଟ କାହିଁକି? ନର୍ମାଲି ଆପଣ କହିବେ ଯେ ଏବେ ମୋ ଘରେ ମୁଁ ଅଛି, ଏବେ ଆଉ ଗୋଟେ ଲୋକ ଆସିକି ଆଲେଜ କରୁଛି ଦ୍ୟାଟ ମୋ ଘରଟା ଇନଫ୍ୟାକ୍ଟ ମୋର ନୁହଁ ସେଟା ତାର, ତା ବୋଲି କଣ ଏବେ ଘରଟାକୁ ଆଉ ଗୋଟେ ରିସିଭର କରିଦବା? ସପୋଜ ମୋର ଗୋଟେ ଦୋକାନଟେ ଅଛି, ମିଠା ଦୋକାନଟେ ଅଛି, ଯାହା ଥ୍ରୁ ମୁଁ ମୋ ଘର ଚଳୁଛି. So ଏବେ ଆଉ ଗୋଟେ ଲୋକ ଆଲେଜ କରୁଛି, ଏବେ because both the parties are disputing it, so should the court order appointment of receiver? ଆଉ ଗୋଟେ କିଏ ଆଉ ଗୋଟେ କିଏ ରଖିବ, ଏବେ ଆଉ ଗୋଟେ କିଏ ସବୁ ଯାକ ତାର ପ୍ରଫିଟ କଲେକ୍ଟ କରିକି ରଖିବ, ଏବେ ସେ ଲୋକଟା ଚଳିବ କେମିତି? So it is harshest remedy only where it is of such nature that court thinks that it is necessary to appoint a receiver. Then for it exercising its judicial discretion, it can order for appointment of a receiver. So as I told you, it is normally given to a third party when dispute is between two parties and it requires management and accrues profits which is of high value. बहुत high value ର profit ହେଇଥିବ, in that case normally receiver appoint ହୁଏ. ସେଠି ସେ ସବୁ normal day to day affairs ସବୁ କରିପାରିବ except sale ଛଡା ନା normal day to day affairs କରିପାରିବ, manage କରିପାରିବ generally. But ଯଦି କିଛି special ଜିନିଷ କରିବାକୁ ଚାହୁଁଛି, suppose ଗୋଟେ ଏବେ କହିବ କି ଯେ ମୁଁ ଏବେ ତାକୁ ଲିଜ୍ ଦେବାକୁ ଚାହୁଁଛି, that is a special thing, that is not day to day management. So in that case you must apply before the court and show how it is beneficial for that property. So ଏଠି କିନ୍ତୁ ଆଉ ଗୋଟେ କଥା, ଯିଏ ଏବେ ରିସିଭର ଆପଏଣ୍ଟମେଣ୍ଟ କରିବା ପାଇଁ କହୁଛି, he must prove the case prima facie case ତାର prove କରିବାକୁ ପଡିବ, ଯାହା ଆମକୁ ବତେଇଥିଲି ଯେ on the face of it he has a case and that's why he wants that a receiver should be appointed. He has to show that. That is what introduction of the receiver is. Now coming to the rules, rule ରେ କହୁଛି କଣ? Rule 1 says that if the court thinks just and convenient, then he may order that if he may order that a receiver may be appointed, or कौन order କରିପାରିବ that remove any person from possession or custody, ତା possession ରେ ଅଛି ତାକୁ ସେ possession ରୁ କାଢି ଦେଇ ପାରିବ for that purpose, କାହିଁକିନା କାଢିଲେ ତ ଆଉ ଗୋଟେ କାହାକୁ receiver କରିବ. Commit the same to possession, custody or management of receiver. ତାପରେ ସେଇ ଯୋଉ ଯାହାକୁ ଆଉ ଗୋଟେ ଲୋକଠୁ possession, ସେଇ mall ର example ରେ mall ର possession ରେ ଆଉ ଗୋଟେ କିଏ ଥିଲା, ତାକୁ କାଢିକି ଏବେ receiver possession ରେ ଦବ, ସିଏ commit the same to the possession, custody or management of the receiver, or confer upon such receiver such power to bring and defend suits, realize, manage, protect, preserve, improve, collection of rent and profits, and execute documents as if he is the owner. So ये सब power दे परिवो receiver को that you defend the suit. यदि किसी suit against करछि mall against you can defend it. If mall is necessary to file a suit, you may bring it. ଯଦି କିଛି realization of fine ଅଛି or payment ଅଛି ସେଟାକୁ realize କରିପାରିବେ. ଯାହା management ଅଛି ସେଟା କରିପାରିବେ. protect କରିପାରିବ mall କୁ ଯାହା ଦରକାର ଇଏରୁ preserve କରିବ mall କୁ improve କରିବ ଯଦି ଦରକାର ଆଉ କିଛି ଏବେ ବଢେଇବା ପାଇଁ for the benefit of the mall you can do that. Rent ଯାହା ଅଛି that you can collect. Profit you may collect. Execute documents which are necessary ସେଟା ବି execute କରିପାରିବ as if it was the owner. The court can do what? He can appoint a receiver out ଯାହାର position ରୁ କାଢିକି ସେ receiver କୁ position ରେ ଦେଇକି receiver କୁ ଏ ସବୁ power ବି ଦେଇପାରିବ. So it can do so, but ସେଥିରେ ଗୋଟେ condition ରହୁଛି that right of the party on the subject matter of this. So subject matter ଯାହା against the receiver order ହଉଛି the party who is applying he must have a right on that. ଏମିତି ନୁହଁ କି ଯେ ଆଉ ଗୋଟେ normal ମାନେ ଏବେ I am no way concerned with the case. I'll just go and file a case, file a petition, file an application that a receiver may be appointed and he may be not kept in position. No, I can't do that. I must have a right in this case. I will prove the case prima facie. If I do that, then only appointment of receiver can be ordered, and for the same, all these things can be done by the court. Now, we knew that power is discretionary and it can be made on application by parties, stranger or suo motu. Suo motu stranger को भी करिपरियो, but he must have a right. तो एमती नहीं कि जे right किछि जदि थिबा ताहाले करिपरियो. Parties तो करिपरिबे, stranger भी करिपरियो if they prove their right. So it कोछि जे if the right of the party on the subject matter of the suit is alleged. से जदि right जहार अछि जदि तार से मोल पर जदि मो parties नहीं still भी मोर right अछि, then I can apply for appointment of a receiver. And if it is for the ends of justice, the court can very well do so. Rule 2 रे कहला remuneration fix करि परिया ता माने receiver को जहा पैसा गोटे salary भलिया देगी ताको रख परिबा जे salary नियो तमे एतिकी तमे काम करूछ जेतु फ्री रे थोड़ी से बसी के ना पड़छि आधार किछि काम नै ता घर चलियो. So for that matter you can order a salary or remuneration which can be fixed by the court by general or special order. Rule 3 रे कहला duties of the receiver. कौन करिवो receiver duty that जदी देखुची कोर्ट देखुची जे एते बड़ प्रॉपर्टी ता जे ता पई सिक्योरिटी ऑब्टेन करिया दरकार. जे मॉल टा is a huge mall, I can't just give it to the receiver just like that. The court is of the opinion that किछि सिक्योरिटी रखिया कथा से receiver to, and for that matter बड़े सिक्योरिटी ऑब्टेन करा जाय. और ताको और भी कोन ड्यूटी अछि तार सबमिट अकाउंट्स. तो अकाउंट सबमिट करिवो जहा डे टू डे अकाउंट्स कला सेटा सब सबमिट करिवो. पे ड्यू अमाउंट्स जहा ड्यू अछि अमाउंट गुडा से सब जाक पे करिवो और डिपॉजिट करिवो. आउ भी तार कोन ड्यूटी जदि किछि लॉस होउची which is because of his willful default or gross negligence, then he'll be less responsible for the same. So जदि किछि लॉस accrue करूची to the property for his willful default or gross negligence, then he can also be held liable for the same. Now coming to rule 4. Rule 4 talks about enforcement of his duties. जदि duties अछि ताले ताकू enforcement भी करिया दरकार. So एठी होजी जदि एई जो चारटा ड्यूटी देला फर्स्ट ड्यूटी तो फर्निश सिक्योरिटी फैनी दैट इज अनदर थिंग. सिक्योरिटी नदल तो ताकू रिसीवर ही अपॉइंट करा जीवन. So that is secondary. बट ए जो तीनटा ड्यूटी रहिला ता छडा ए छडा जो बी सी डी रहिला सबमिट अकाउंट्स माने आफ्टर ही हैज बीन अपॉइंटेड. फर्निश सिक्योरिटी तो बिफोर ही इज अपॉइंटेड रिसीवर. सो ताकू अपॉइंट करिया पई आपण सिक्योरिटी मांगछन जे सिक्योरिटी देलान तो रिसीवर ही अपॉइंट हैला. बट थरे रिसीवर अपॉइंट हे गला तार ई बी सी डी तीनटा ड्यूटी होची सबमिट अकाउंट्स, पे ड्यू अमाउंट्स, responsible for any loss accrued to his by his willful default or gross negligence. If it is done ए तीनटा छडा तीनटा होची ए फर्स्ट छाडी की यदि से तीनटा किछि करूची जे लॉस होची तारो willful default पई किंबा gross negligence पई, or he is not paying the accounts, or submitting the accounts, or he is not paying the amount dues, then in that case the court may order for attachment of his property and make good from such proceeds and pay the balance to the receiver. तो से कौन करिवो that receiver रा personal property को भी attach करिवो. तार property को attach करिकी कहबो जे तो property रो पैसा बाहर करावो. एबे आपण कहबे isn't it a bit harsh because ये तो निजे चाहि नथला रिसीवर हवा पई ताको एबे कोर्ट आपण अपॉइंट करथिले तापरे एबे कहउछन जे किछि लॉस हला बोली ताको लायबल करिवा नो यू आर गेटिंग अ रेम्यूनरेशन फॉर दैट सो इट इज नॉट लाइक यू आर डूइंग इट प्रो बोनो you are doing it for a remuneration. So in that case, if any loss is accrued or you don't pay the balances or accounts, would accountant type na court se manager and accountant type would. If he is not doing that properly, then in that case, it will be his personal property will be attached and sold, and proceeds will be used to make good to that property. जहाँ भी property loss है तार property टाको ठीक करिया ପାଇଁ use कराई परिबो ଆଉ ତାର ବାଲାନ୍ସ ଯାହା ବଞ୍ଚିବ ସେ ପ୍ରପର୍ଟିରୁ ତାକୁ ଫେରା ଯାଇପାରିବ ରିସିଭର ଏଟା ବି କୋଉଟେ କହିଛି ଯଦି ସାଂକ୍ସନ ଅବଟେନ୍ ନ କରିକି ସେ କଣ୍ଟ୍ରାକ୍ଟ କିଛି କରିଦଉଛି ମୁଁ କହିଥିଲି ଯେ ଜେନେରାଲ ପାୱାର ପାଇଁ ତାକୁ କିଛି ଦରକାର ନାହିଁ ପରମିଶନ ନେବା ସବୁବେଳେ ପାଇଁ ସବୁ ଯୋଉ କଣ କହିବ ଯେ ଏବେ ଆଚ୍ଛା ଆଜି ମୁଁ ରେଣ୍ଟ କଲେକ୍ଟ କରିବି ଯାଉଛି ପୁଣି କୋର୍ଟକୁ ପାଇଁ ଆଚ୍ଛା ମୁଁ ଆଜି ପ୍ରଫିଟ କଲେକ୍ଟ କରିବି କୋର୍ଟକୁ ଯିବି नो फॉर डे टू डे अफेयर्स यू नीड नॉट बट फॉर स्पेशल फंक्शंस दैट यू नीड टू परफॉर्म फॉर दैट ଯଦି ତମେ ଆପଣ ଚାହୁଁଛନ୍ତି କିଛି କରିବା ପାଇଁ you need to take permission of the court and if you don't do that if you don't take sanction and you still enter into a contract you try to sell then he will be personally liable for this breach of contract or the attempted sale as the case this is rule 4 rule 5 रे कहला कोन that the collector can be appointed receiver it is same katha jodi the subject matter that is the property if it is land paying revenue to the government सेठी government को किछि revenue मिलुची and it is necessary in the interest of those concerned जदि जो माने से पार्टीज अछंती तांकर इंटरेस्ट ता बेसी प्रोटेक्टेड हबो if the collector is appointed then with the consent of the collector he may be appointed as a receiver सेठी आपण ताको receiver appoint करि परिवे if it is in the interest of the parties and the second condition is that the property must be a one which is paying revenue to the government then the collector may be appointed as a receiver and what are the remedies available if you reject appointment of a receiver or if you allow appointment of a receiver then you can appeal as well and you can revise the same as well this concludes our discussion on appointment of receiver and interlocutory orders as I told you it is a very short topic nevertheless we had to discuss it and get away with it tomorrow we'll move to another crucial discussion that is order 13 order 13 we'll discuss if there is any doubt from the topic that we discussed today it may be put right away I don't think there is any doubt if there is any doubt from the yesterday's class it may be put as well also I yes somebody was asking about Ranjita ma'am who was asking about
सर नमस्कार
नमस्कार धरित्री ma'am yes
आज्ञा सर रिसीवर जो अपॉइंट होजी ताको कोर्ट पेमेंट करूची ना पार्टीज पेमेंट करछंती
जो रेम्यूनरेशन टा फिक्स कराबो ना सेटा that will be in fact given out of that property I believe कोर्ट तो निजे पे करिवनी तनो से प्रॉपर्टी रू
आज्ञा
ही पे
आज्ञा
करियो
प्रॉपर्टी रू ही पे होबो आज्ञा
प्रॉपर्टी रू ही पे करियो आपण त निज हातरू थोड़ी कोर्ट पे करियो एक्सचेकर काई पे करियो बिकॉज़ सिविल सूट इज बिटवीन टू प्राइवेट पार्टीज so in that case state is not even interested it is because you guys are in dispute that's why the suit has taken place so from that property itself the remuneration will be kept aside कांगना से जे भी नॉर्मल लोक भी जे मैनेज करथंदा the common sense demands that नॉर्मल लोक भी जे जदी पार्टी भी मैनेज करथंदा he must have appointed a manager गोटे मैनेजर अपॉइंट करथंदा ताको पैसा देथंदा now that court has done because to make sure that it is impartial nobody challenges it and nobody says that any घपलाती किछि हेछि बोली सेटा को चैलेंज न करू that's why court does it so remuneration has to be given out of that property itself another I hope it is clear another question was
yes
put
sir
yesterday I believe the question was whether intervener will be allowed to file an injunction and the intervener against him can an injunction will be filed can be filed the answer to both of them will be yes I actually went through it properly and I am of the opinion that it will be both it can both be filed against the intervener it can be filed by the intervener as well the reason being once he makes himself a party once he intervener ଯେତେବେଳେ ଆସିକି ଗୋଟେ application ଦବ, he will ask the court to implead him as a party, and party that by that means that he must be either a necessary party or a proper party. Then only he may be impleaded. Once he is impleaded as a necessary party or proper party, then in that case he can both file an injunction and he can also be liable against an injunction. Both ways he'll be getting the right, and get he'll be having that duty as well to abide by that injunction. So that is the answer. I hope ma'am is there from. Yes, Reena ma'am has a doubt. Reena Patel ma'am has a doubt.
Sir, namaskar, sir.
Namaskar.
Thank you, sir. Clear for me.
Oh, you had asked that question. Yes,
Yes, sir.
I was confused between Reena and Jagyasini ma'am. So I was about to take your name, Reena Patel. Now I remember.
Yes, sir.
Yes. So yes, that will be the
I
answer to
haven't
your
doubt.
question.
Yes, sir.
Now are you clear?
Yes, sir. I am clear now.
Okay. Okay.
Sir, there
So
is a
as I
doubt.
told you, yes. Any doubt?
Sir, in the enforcement of duty of a receiver,
Yes.
court may order for attachment of property, his
Yes.
personal property, if
Yes.
the receiver has no such property, except the security he has furnished during his appointment, then what will be the remedy, sir?
See, as I told you, he has to furnish a security, right?
Yes.
He has to furnish a security. So he must have good in all cases, all probabilities will never appoint a person who is who is an insolvent person. We will not do so because it knows that there might be a situation where it will be necessary that he might commit a blunder and his proceeds will be taken out of his personal property. So that's why a provision is there that he has to furnish security if called for. Though the provision is if, but I believe the court will always take security before appointing him as a receiver because he is entrusting him a property which is not his own. So generally, human tendency is that if it is my property or my own property, I'll manage it very carefully. Once I know that it is my, it is not my property, it is someone else, I'll try to do something fishy about it. So court
Okay.
in all probabilities will always appoint someone who has furnished a security, even though the provision says that it is if the court desires he may obtain a security. I believe it is always a must. It has to do so at least even if he does not furnish take a security. ଯେମିତି ଏବେ ଗୋଟେ ନର୍ମାଲି ଗୋଟେ ଆମେ ଦେଖିବା ଯଦି ସିକ୍ୟୁରିଟି ଦରକାର ବି ନାହିଁ କେତେବେଳେ ସିକ୍ୟୁରିଟି ଦରକାର ନାହିଁ ଗୋଟେ ଦେଖିବା ଯେ ହି ଇଜ ଏ ସାଉଣ୍ଡ ପର୍ସନ ସେ ଜାଣିଛି କି ଇନକ୍ୱାରି ଦେଖିଦେଲେ କି ଆର ଏତେ ପ୍ରପର୍ଟି ଅଛି or he's an influent person. In that case, court will not. But normally, ଯଦି ଗୋଟେ ଏରା ଗେରାକୁ ଆଣିକି ତ ଆପଣ ପ୍ରୋସିଜର କରିବେନି ନା.
Okay, sir. Now I got it, sir.
Yes.
Thank you.
Welcome. Anything else? Okay. So if no questions, we'll discuss about the exam that will take place on Sunday. I had sent the detailed guidelines. I did my best to answer all your doubts. Still, if you have any doubt about the exam, you may put it because tomorrow there will be a session which will be comparatively long, I believe. So we may not take all the doubts if there is because we have time left. If there is any doubt for the clearance, I may again recite at there will be 4 questions which will be 12.5 marks each. All will be in fact one or two of them will be problematic questions, so 2.5 into 5 questions which will be compulsory, and 2 questions will be long questions. In that or will be given, so between 2 questions you will have to choose one and answer. गोटे आपण चूज करिवे दीटा रु लॉन्ग क्वेश्चन को आपण गोटे आंसर करिवे जो पांचटा थिबो तादरु पांचटा रु आपण को पांचटा को आपण अटेंड करियो पड़िबो आ 5 मिनिट आगुरु आपण को क्वेश्चन दिया हबो 1 hour 15 minutes ड्यूरेशन सो 7 to 18 8:15 रे the exam would end 8:15 ରୁ 8:30 ଆପଣଙ୍କୁ ଦିଆଯାଉଛି to click the pictures ତା ଆଗରୁ ଯଦି ଆପଣ ସାରି ଦେଲେ ବି you click pictures or you scan it. If you have turbo scan or any scanner for that matter, that would be really good. It will be easier for us. Even if you do not have a scanner or anything, at least make sure you have a good I mean you click it very properly. You do not haphazardly nature because it will be difficult to evaluate again. So please take a भली उठेबे and number करथिबे पेज नंबर करथिबे कारण आपण उठी कि पठेला बेलକୁ से 1 2 1 1 2 3 टा जदी सिमिलरली ऑर्डर नथियो त असुविधा है आपण फर्स्ट पेजेस गुडा नेले आ 10 टा 15 टा पेज नेले स्टैपल कर दे स्टैपल करके नंबरिंग कर देले आ ऊपर लिखि देबे पूरा आपनकर ना नंबर ईमेल आईडी नेम ऑफ यूनिवर्सिटी भी सब लिखि देबे and then you start writing one by one. After it is finished, you click a picture, turn, click a picture, turn. যদি পিডিএফ করি পঠাই পালে বঢ়িয়া কথা নহলে भी खाली भी যদি ইন্ডিভিজুয়ালি ফটোজ পঠাউଛନ୍ତି still it will consider it but make sure you page them মানে first ଯେତେବେଳେ ସ୍ଟାପଲ କରିବେ 1 ତାପରେ 2 ତା ପଛରେ 2 ତାପରେ 3 ତାପରେ 4 ଏମିତି କରି ସବୁ ଯାକ ପେଜ ରେ ଲେଖିବେ so that ଆମକୁ ଆଉ difficult ହବନି ଆଉ to evaluate your answer. Okay, 8:30 रे 8:30 will be the last deadline. 8:30 रे जे भी सबमिट करिवेनी तापरे इवैल्यूएट हबो but for the purpose of examination it will not count. So marks आपन को मिलिबो इवैल्यूएट आपन को करिक आपन को पर्सनली मु पठे देबी but marks will not count. Okay, I hope it is clear. Chalo, have a great day. Will be
sir namaskar.
Okay, namaskar. Anyone has a doubt? Who is it?
Sir Nisit.
Nisit, I can't see. Okay, tell me Nisit, what is it?
Sir A4 size paper both side रे sir लिखिबु ना अलग
both
अलग
side
पेपर
रे लिखिबे काहे आपण स्कैन करला बेलू मु जानि परिबिन ना which is which side you
आगे
write on both side one two लिखु किछ असुविधा नहीं आपण you take the picture no so both side
आगे
लिखु
sir
one side लिखु आपण यदि one side लिखबे in fact it is easier because आपण को मे बी टिके छापी जो यदि भलो क्वालिटी नथो ताले नेक्स्ट फॉरवर्ड को पळे आसीबो तो यदि one side लिखिबे
yes
तो
sir
well and good but यदि both side भी लिखबे at least you page them and then you turn over and click the
आगे
picture
sir
that is
sir आ गुड डाउट होजी सर का
कोई
आल्सो मोर सर ओजेस भाई गुटा जिंस डाउट सर जो क्वेश्चन आंसर जो लॉन्ग क्वेश्चन पढुची हम सर बेयर एक्टर एग्जैक्ट लैंग्वेज लिखियार अछि ना सर समहाउ किछि माने लैंग्वेज न मन पड़ला एग्जैक्ट कि चेंजेस करले सर किछि प्रॉब्लम मार्क फेचिंग कम हो ना सर किछि अछि
I would suggest it that कि आपण देई जोनु थरे एग्जाम जे व्हाट डू यू थिंक फर्स्ट एग्जाम थरे दियंतु when the मु इवैल्यूएट करला को आपण खाली मार्क्स देबे आई विल मेक श्योर दैट यू गेट द फीडबैक that how the answer could have been written and in what way you have messed up.
ओके सर
Okay, जदि भी
यस
जहां
सर
भी आपण भूल जदि हेतिबो सेठी आपण देखिदेबा और नेक्स्ट तला में डिस्कशन करिवा द आंसर you will get a clarity that it केमती वे रे लेक्चर थिला but how you did not write and that's why we'll discuss them on that.
सर सर बेले बेले गोटा लैंग्वेज सर बेयर एक्टर बहुत लेंथी हो जाउ सर मन रखिया
but
पई
but
प्रॉब्लम हो
generally I would suggest do not go for bare at exact provision. At least if I am the examiner, I would never mark you the most. नहीं करेगी average mark नहीं करी but most marks केवे देबेनी if you have exactly cited the bare and the
थैंक यू सर
reason of course being at your online exam there is possibility that you copied it if it is exact bare. Okay,
थैंक यू सर
not
सर
you.
मैम
I'm just saying generally. I know
सर
you will
मैम
not
सर
copy.
सर मेमोराइज करिया में प्रॉब्लम हो जतो जिंस
So better you do not write whereas it gives an impression that you did not copy it or you did not just mug up and produce. You had
थैंक यू सर
understood the concept and you produced it in your own language. Oh, of course. आपण इलेक्शन जगह एठी आ कोन
ना
अलगा
सेमती सेम
वर्ड
तो
लिखि
नुहे
देबे हां
ना
बट
सर कहूँ बेले जो कमा फुल स्टॉप
substance
बीजा मार से सब जिंस
no
गुराक
no 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 never आपण substance टाको as such produce करंतु ना even though खाली legal terms which are very necessary you write
यस सर
necessary party जगह रे आउ necessary party जगह रे needed party no you can't write but अलगा necessary party टाको explain कला बेलू what is a necessary party if you write it in not in the exact words that have been given I would not make nobody would make
थैंक यू सर थैंक यू सर
okay okay so thereby we are ending the discussion today we'll take the class tomorrow at 7 p.m. Thank you.